Let's be honest, every single case you will ever run is going to turn on evidence. But here in Queensland, getting that evidence in front of a judge, well, it's not just about what you've got, it's about how you present it. And it all boils down to one crucial question you have to nail right from the get-go. Today, we're diving into the playbook that has all the answers, Chapter 11 of the UCPR.
All right, so here's our game plan. We're going to tackle the 4 pillars of evidence that you are going to rely on day in, day out. We'll start with the 2 default modes of evidence, then look at how to compel evidence with subpoenas, get our heads around the rules for experts, and finally, how to perfect those all-important affidavits. Let's jump in.
Okay, first things first. The very first question you have to ask yourself is, what's my default mode of evidence? And this isn't really a choice you get to make. It's dictated by a foundational rule you need to burn into your brain. That rule is Rule 390.
So Rule 390 basically creates a fork in the road. It's simple. If you've started your proceeding with a claim, your default is oral evidence at trial. Think witnesses in the box giving testimony. But if you've started with an application, your default is written evidence, which means you're drafting affidavits. Getting this right from day one is going to shape your entire strategy. So you figured out your default evidence type. Great. But what happens when the smoking gun, that crucial document, or that key witness is in someone else's hands? Well, that's when you use the power of the court under Part 4 of the UCPR, which is all about subpoenas.
The one you'll probably use most is the subpoena for production. This is on a Form 41. This is how you get a bank to hand over financial statements, or how you get a hospital to produce medical records. It forces them to bring documents or things directly to the court. Next up, you've got the subpoena to give evidence, which is Form 42. This one does exactly what it says on the tin. It compels a person to physically show up in court. So if you've got a reluctant eyewitness who saw the whole thing, this is the tool that ensures they get into that witness box.
And, of course, there's the hybrid option, Form 43, the subpoena for production and to give evidence. This is just a super efficient way to do both at once. It's perfect for, say, a company's bookkeeper, who not only needs to bring the financial reports, but also needs to get in the box and explain what they mean.
Now, issuing a subpoena isn't some kind of dark art. It's a really clear 4-step process. First, you file a Form 44 request under Rule 414. Then, you serve it properly, following Rule 421. But, and this is so important, pay attention to Step 3. Under Rule 419, you have to provide conduct money for their expenses. If you forget that, they are not legally required to show up. It's a critical step.
Just a word of warning, though. Issuing a subpoena doesn't give you unlimited power. Under Rule 415, the person who receives it can apply to the court to have it set aside. Maybe what you're asking for is totally irrelevant. Maybe it's covered by privilege. Or maybe it's just oppressive. Way too broad and burdensome. So you've got to draft these things carefully to make sure they can withstand a challenge.
Okay, let's move on to what is, without a doubt, one of the trickiest areas of evidence for any barrister, expert evidence. This whole world is governed by Part 5 of the UCPR, and let me tell you, these rules are non-negotiable.
If you remember just one thing from this entire explainer, please make it this quote from Rule 429F. An expert's #1 duty, their paramount duty, is to the court. Not to you, not to the client who's paying their invoice, to the court. Every single conversation you have with your expert has to be viewed through this lens.
So this expert, whose primary duty is to be an impartial assistant to the court, how do they actually give their main evidence? You might assume they just hop into the witness box and start talking, but the default method is actually something else entirely.
That's it. Their evidence in chief is given through their written report. Rule 429G makes this crystal clear. The report is the evidence. It gets tendered, and then, of course, the expert can be cross-examined on what's in it. This means the quality, the clarity, the thoroughness of that written report, it's absolutely everything.
And to make sure that report is up to scratch, Rule 429H is incredibly specific about what has to be in it for it to even be admissible. It has to spell out their qualifications, list all the facts they relied on, explain the reasoning for their opinions, and, this is a big one, it must include a statement confirming they've read and agree to be bound by the expert code of conduct.
All right. Finally, let's talk about the document you are going to draft more than any other, especially when you're working on applications, the affidavit. Nailing this is a fundamental skill, and all the rules you need are sitting there in Part 7.
So what's the golden rule? It comes straight out of Rule 430, and it's beautifully simple.
An affidavit can only contain things that the person signing it, we call them the deponent, could actually say from their own direct knowledge if they were sitting in the witness box. That means no hearsay, no guesswork, and no opinions. Just the facts they know firsthand.
But, like any good legal rule, there's a really important exception. And it's an exception you're going to use all the time in practice.
And that exception, which you'll also find in Rule 430, applies to interlocutory applications, the non-final ones. In these, you can include statements based on information and belief. But, and this is a huge but, you absolutely must state the source of your information and the grounds for your belief. Forgetting to do that is such a classic mistake, and it can be fatal to your evidence.
Just think of this as your final checklist before you even think about filing an affidavit. Is it written in the first person with numbered paragraphs? That's Rule 431. Have you used the proper Form 47 certificate for all your exhibits? That's Rule 435. And is the jurat, that's the swearing part at the very end, is it absolutely perfect? Check Rule 432. Getting these small details wrong just looks sloppy, and worse, it can get your evidence thrown out.
And that's it. That's your Chapter 11 playbook in a nutshell. It all starts with knowing your default mode under Rule 390. It gives you the power to compel evidence with subpoenas under Part 4. It keeps you honest with the ethical duties of experts under Part 5, especially Rule 429F, and it forces you to be precise with your affidavits under Part 7 and Rule 430.
Look, this stuff isn't just theory to help you pass an exam. These rules are the actual tools that separate a beginner from a truly effective advocate. Mastering them is, genuinely, the foundation of your entire practice at the bar. So take another look at that list and be honest with yourself. Which rule are you going to go and check first?